My name is Professor Bill Rees and I am a barrister and I practice from Atlas Chambers in Gray's Inn in London, and one of my areas of specialisation is immigration law. And today I want to give a short introduction to asylum law. There is of course a very strong political climate in which this law operates today in the UK. There can of course be a difficult clash between the right of a state in relation to control of people on its territory and, on the other hand, the fundamental rights of individuals. The prospective applicant refugee has to apply to the Home Office for refugee status, and if that person is unsuccessful in that application, then he or she can proceed to the Asylum and Immigration Tribunal, the AIT. And the claimant will, or himself or herself, will find themselves up against the Secretary of State for the Home Department, the Home Secretary. And the Home Secretary is always represented by a Home Office representative and occasionally by a barrister, at least at first instance, before the Asylum and Immigration Tribunal, AIT for short. Increasingly in recent years, the higher courts have been called on to consider the very complex legal and policy issues in relation to the UK's handling of asylum and the necessarily related Human Rights Act concerns in the applications. So, set the scene. Applicants start at the Asylum and Immigration Tribunal, and I have to say that relatively few applications succeed. Nevertheless, they may end up in the higher courts in some cases, and this would be either on an appeal from the AIT or on a judicial review before the High Court. There's been a lot of UK legislation, both primary and secondary, in other words, Acts of Parliament and also regulations and rules in recent years. Asylum seekers or refugees, if they get the status that they are seeking, are normally people who fled their own countries in desperation in order to escape persecution. This could be racial, religious or political, for example, or perhaps to escape a civil war. The general definition of refugee is in Article 1A2 of the 1951 UN Convention on the Status of Refugees, and that's been amended by the important 1967 Protocol. And let's look at the key elements in this now. First is there a well-founded fear of persecution? And the Convention also sets out the reasons, and this is, to be absolutely precise now, for reasons of race, religion, nationality, membership of a particular social group, or political opinion. And the person has to be outside the country of his or her nationality, and that person cannot, or owing to such fear, is unwilling to avail himself or herself of the protection of their own country, or it is a situation of that person being unwilling to return to it. A refugee, as such, has a right not to be expelled, and they'll be given a right of leave to remain in the United Kingdom if they're successful. The provisions of the Refugee Convention are given effect in domestic law by Rule 328 of the Immigration Rules. The Convention, according to the Court of Appeal, has to be viewed as a living instrument, adopted by civilised countries for a humanitarian end. That is the fundamental concern here. And the House of Lords, in its judicial capacity, has spoken about the words of the Convention needing to be given a broad meaning. For example, no internal relocation in the person's own country is possible if a person is to succeed in getting refugee status. And there then is, of course, the Human Rights Act of 1998, which brought into UK domestic law the provisions of the European Convention on Human Rights. And I will finish on the note of pointing out that Article 8, the right to a private and family life, is very important in this context. Thank you very much.